If you're buying an accounting practice, you're probably going to encounter a purchase agreement at some point, and they can be very intimidating. So I'm making this video to show you the very exciting topic of the anatomy of a purchase agreement. Because I see hundreds a year, I do view them all as having commonalities, or at least they should. So when you go through a purchase agreement, there's stuff that I'm always looking for, having reviewed so many, that I'm gonna highlight for you. This is gonna be dense, so buckle up. Before I dive in too far, if you think that this is interesting content, bless your heart, and please subscribe and comment, because this is what I do every day. So I love it, but not everyone else does. But if you're buying an accounting practice, you need to read your purchase agreement. They're usually asset purchase agreements in what I do. And an asset purchase agreement is something that I often liken to your user manual for your refrigerator. So you're not pulling it out of the drawer after you buy the thing unless something's gone wrong. So when I am working with a client, I want to go over the purchase agreement with them with a lot of detail so that they know where they're looking for things and they remember it in their mind. Oh shoot, there was a document that talked about that. Because when closing passes and you go, as something bad happens, you go to pull this back up, like you're gonna hope that whatever bad eventuality came up is addressed in there, because this will tell you your rights and remedies. So you may not enjoy it too much from a casual reading perspective, but they do all include a lot of the same parts. So I would say that there are 7 sections of most asset purchase agreements, and they usually actually follow the same path too. So mine are in articles, some are sections, but we'll say Article 1. Article 1 is usually where everybody talks about the very specific things. I think it's because the parties don't want to have to flip too far for the things they care most about, like the purchase price or the list of the assets they're getting and the assets they're excluding. So all of the purchase agreements are usually designed so that there can be an appendix that is a disclosure schedule. You might see a statement that says purchased assets, buyer buys everything unless it's specifically set forth as an excluded asset. And then you go down to excluded asset and it says everything is a purchase asset except for those things that are specifically excluded as set forth in disclosure schedule 2.07 or whatever. And so then you go to the disclosure schedule, and that's where people will list out all of the things that are excluded. The funny thing is the attorneys like to go back and forth on where the burden of proof or the default is. If I'm representing the buyer, I want the assumption to be that everything is a purchased asset unless the seller specifically listed out that it was excluded. When I'm representing the seller, I want everything to be an excluded asset unless it's specifically called out to be a purchased asset. Usually you wind up in the middle with long lists on either side. So that's Article 1. What are you buying? What's included? What's excluded? What are you paying for it? Is it by cash payment? Is it by promissory note? Are there any rules related to that promissory note, like a purchase price adjustment or a retention adjustment? And then at the very end, I usually put the allocation of the purchase price in there too, which I will talk about in a different video because it's so niche. If you like this one, you will love allocation of a purchase price. So I will link that one here. And then I go into conditions precedent to closing, because for these, I like my documents what is called a bifurcated sign and close. So I will also talk about the different closing mechanics later, because that's a bigger issue. So bifurcated sign and close just means we're going to sign this purchase agreement when the parties agree to it, and it'll close later. So when that happens, you have to draft everything with that in mind. So the whole agreement needs to talk about, like, sure, we've agreed to this, but you're agreeing that as of the date of closing, this is going to be true. And we have to do some clever other drafting to make sure that we're capturing all of the things up through the day of closing. Generally speaking, your purchase agreement matters for a lot of reasons, including because that's where your breach of contract claim against the other side lives. So even if somebody, and there's an integration clause on most of these, an integration clause is usually, it says entire agreement, and it says this agreement supersedes all written or oral understandings that existed prior to it. In general, that's like a drunk history version of an integration clause. But what that means is it doesn't matter if you talked about something all day long with the other side and this agreement that you're about to sign says something different. The talks don't matter, the agreement controls. So you have to be really careful that it matches up what's going on. So as a business person, you're going to spend a lot of time looking at Article 1 and making sure that it's the right dollar amount, it's the promissory note amounts, it's the right interest, it's the right everything. and then you're gonna move on because the rest is a little bit more lawyery. Then you get into Article 2, which is usually closing mechanics. I'm gonna talk about that later because there's a couple different ways to close it, but generally I like to talk with everybody about what they experience on closing. And ideally, a perfect closing is incredibly underwhelming. And you'll go, why did I pay all these people for this? This was nothing. That means it went well. Trust me, because if you're there almost at midnight and you're exchanging more DocuSign packets, you're gonna be really upset. Maybe that'll be more of the experience that you anticipated, but it is not the experience that your helpers like me want for you. So then you go to Article 3, which is almost always representations and warranties. And that's just this big long list of promises the seller and the buyer make to each other. If they are lying, you have a breach of contract claim against them. So they're supposed to be really expansive. And things like my financial statements are accurate and I own the assets I'm selling you. Things that are pretty obvious, that I really exist and have a right to enter into this agreement, that I haven't sold the assets to somebody else. I haven't lied in my billing, that I'm not being sued. Nothing new has come up since we first started talking about this deal that has made it no longer true. You know, something sneaky and terrible has happened, but I haven't let you know, but I didn't lie to you the first time, so it's a lie by omission. That type of things. When I'm working with my sellers, we read every sentence together, or I give them the homework to read every sentence together because you want this to be true. And the second best part of Article 3 in these reps and warranties is not so much that you're getting these people to commit to something so you have a breach of contract claim if it's not true. It's that you're getting them to take a good hard look at something and say, I'm not sure if this is relevant, but I am being sued, which happens all the time. So people may, in your diligence request list, not have asked something in the most holistic way, or you may have accidentally given them the opportunity as the seller to underreport what's going on. In this type of exercise of having to sign several pages of representations and warranties is what encourages them to go, well, just to be safe, let me go ahead and let the buyer know that I am in collections against somebody who didn't pay me, or I had a slip and fall 3 years ago that my insurance is still working out, or that I have a wage claim from a disgruntled employee who's suing me for overtime, which I think is silly, but nevertheless, let's go ahead and disclose it. Super powerful part of the process is getting those reps and warranties in Article 3. Then you get to Article 4. I know, this is so exciting. You're having a great time. Usually Article 4 is the reps and warranties of the buyer. So you'll have 3 being reps and warranties of the seller and 4 being reps and warranties of the buyer, which are pretty limited in just like the really high level things. I have a right to enter this agreement. Sometimes it'll include, I'm not being sued by anybody, things like that. Then you get to Article 5. Covenants are big promises. And anybody who has a religious background will know that that's like big promise on tablet is a covenant. Reps and warranties are promises of the way things were up until closing, and covenants are promises of future behavior. And the most common type of covenant that we all encounter on a day-to-day basis is a restrictive covenant. And so a restrictive covenant is a promise not to engage in future behavior, like not to disparage, not to disclose, not to compete, and not to solicit. So those are usually in Article 5, and that's where you flip through for the non-compete. So you want to make sure that if you're the seller, that those non-compete, obligations are something that you understand. That's my goal, is to be able to be specific enough in a non-compete that I can explain to my client how he or she can comply with it. And sometimes they're so broad that I can't. And that's a problem. As the buyer, you want to make sure that you've included what you meant to. So you didn't accidentally say, well, you can't engage in accounting in a 10-mile radius and forget to also encompass any of the client lists that you're buying. You want to really make sure that those are very specific. A lot of times we wind up with additions saying, notwithstanding the foregoing, which is lawyer speak for. Also, you can continue to do some other stuff, including free tax returns for your family and friends. So all of that gets negotiated in that 5th article, which is covenants. It's all promises of the future behavior. So it also includes stuff like further assurances, which is just a way of saying, hey, if we all need to enact another document to make all of this that we're trying to do happen, we'll work together in good faith to do it. Then Article 6, indemnification is fun because it's kind of one part dispute resolution between the parties. So if anything has come up in the covenant or the breach of contract and reps and warranties, it's going to be handled usually through the indemnification clause. So before this, everything in the agreement is between the two parties. It's buyer, seller, buyer, seller, buyer, seller, or buyer, seller, seller, owner, whatever. It's the parties of the agreement. This is the first time we talk about like, what happens if a third party enters stage right and is suing somebody, because I started out as a litigator, and I can promise you, law litigators sue everyone they can. So if there's something that's on that straddle period, it is very likely, if there's a lawsuit, that it will scoop up both the buyer and the seller. So how are they going to tease those claims apart? The general thought process for an asset purchase and for professional services is that the occurrence giving rise to the claim, it's kind of like insurance. You pull back to when that occurrence giving rise to the claim happened. And if that was on seller's watch, that's their issue. And if it was on buyer's watch, that's their issue. And they'll pay each other back if they accidentally get drug into each other's space. So usually prior to closing, if something comes up and it's the occurrence giving rise to the claim happened then, seller's paying buyer back. If it happens on or after closing, then the buyer's paying the seller back. That is a perfect world. A lot of times there's going to be overlap. And so it's going to be a lot stickier than that. So that's when you get things like survival periods of reps and warranties to limit the seller's exposure, and indemnification caps. Because generally speaking, sellers don't want to sell their business and think that something could happen where then they're out of pocket for having sold their business. And that's a pretty bad outcome for most people. So they're going to try to limit as much as they can. So after we talk about indemnification and all of that, which is really where your lawyers are going to have a field day. They love this provision. They'll want to get so complex. So maybe I'll make another video that's all about indemnification, and it talks about fundamental representations and caps and tipping baskets and all of these silly things that we lawyers get all academic about. That's where we'll go crazy. The next one is usually miscellaneous or boilerplate. And that's still worth reading, because I have found all kinds of things hidden that you wouldn't have expected in boilerplate. So you got to read it, and it doesn't always have to be there. So it all plays a really important role in the whole contract. Let's just say most lawyers breathe a sigh of relief once they hit the boilerplate, because they know what they're going to be reading. It's going to be severability. It's going to be interpretation, headings, entire agreement, the integration clause we talked about, successors and assignment provisions, and how to amend the agreement, which is usually the parties have to agree to amend the agreement, which would be the case if you didn't say anything about amendment. So maybe we should just leave that part out, but it's always in there. All of those things. Then you want to go to your signature line, because you want to make sure the right people are signing. So it's really, really important to know if anyone is signing on behalf of the company and as an individual. We would expect that to be the case. Most of the times companies are going to go away. So we want the seller as an individual to be on the hook for all of those reps and warranties and other things we discussed. And certainly the covenants, right? You don't care if the old LLC is going to compete. You care if Jim Anderson is going to compete. So you really want to make sure that the seller as an individual is a signatory to and a party to the purchase agreement. And then some people take that position about the buyer too, but I actually don't think that that's very true. If you found this helpful, good for you. You should go to law school. But if you don't have time and you don't feel like taking on the debt, then just subscribe and engage with our content, and take a look at our other videos about closing mechanics and indemnification and all of the other exciting things that go into this.